There's a new update coming in the insolvency and bankruptcy law space. This time, the Supreme Court has, for now, allowed project-wise resolution process for a single project of controversial real estate giant Supertech, which is currently undergoing insolvency proceedings. And the court has permitted continued construction of all the other projects by the developer. The order is being touted as a boost for home buyers because up until now what has been happening is that once a builder goes into insolvency, all its projects get stuck in litigation. But now with this order, the court is trying to restrict these insolvency proceedings only to one project. In fact, while doing so, the Supreme Court said that it was allowing this course of action because bringing every project of real estate giant Supertech under insolvency proceedings would put home buyers in a state of uncertainty and cause immense hardship to them. Now, here's what this whole thing is about. The project in question is Eco Village 2 in Greater Noida West. Union Bank of India had initiated insolvency proceedings against Supertech in March 2021, claiming a total amount of 431 crores as on January 2021, along with interest. In these proceedings, the National Company Law Appellate Tribunal, or NCLAT, passed an interim order in June last year, issuing several directions that had the effect of converting the corporate insolvency resolution process into a project-wise insolvency resolution process. So let me break it down for you. For example, what it did was the NCLAT said that the committee of creditors for the process would be restricted only to one Supertech project, which is Eco Village 2. The IRP was asked to proceed to complete the construction of Eco Village 2 project with the assistance of the ex-management, its employees and workmen after the constitution of this committee of creditors. Now, this NCLAT order was challenged by the Union Bank of India and India Bulls Asset Reconstruction Company, both of which are financial creditors for Supertech. They had argued that the NCLAT does not have the power under IBC to allow a project-wise corporate insolvency resolution process. India Bulls Asset Reconstruction Company had also demanded that the committee of creditors must be constituted for the entire company and that the promoters or the erstwhile management of Supertech should have no involvement whatsoever in the insolvency process. But the Supreme Court has for now allowed this project-wise resolution process, rejecting their appeals. Just to reiterate, the overall result of these orders is that the COC, or the Committee of Creditors, will be constituted only for project Eco Village 2, and that the IRP shall proceed with the completion of the project with the assistance of the ex-management, its employees and workmen. As against this, what happens to the other projects? All the other Supertech projects shall continue as ongoing projects, without going through the IBC bidding process and the constitution of COC, and these shall continue with the overall supervision of the IRP, again with the assistance of the ex-management. So they won't be going through the insolvency process as such. But please note that this is an interim order. The Supreme Court's order is interim, so the appeals are still pending before the Supreme Court and have been listed for final hearing in the second week of July 2023. So the Supreme Court even said that the NCLAT order would continue to operate subject to the final orders passed by the Supreme Court in the appeals. It has also directed that with regard to Eco Village 2 project, any process beyond voting on the resolution plan that comes in under the IBC process should only be undertaken with specific orders from the court. Now, the Supreme Court order also talks about the reason why it is accepting this course of action, which is not the usual course. It said that it should adopt the course which appears to carry lower risk of injustice. It then pointed out that the NCLAT had adopted this course while observing that such a project-wise resolution may be started as a test to find out the success of such a resolution. The court said that if at this stage it directs the COC to be constituted for Supertech as a whole, and I quote, it is likely to affect those ongoing projects and thereby cause immense hardship to the home buyers while throwing every project into a state of uncertainty, unquote. The NCLAT had also allowed the promoter of the group, that is Supertech Group, to infuse the funds arranged by them in different projects. The interim resolution profession, or the IRP, is supposed to treat these funds as interim finance and maintain detailed accounts on it. So the Supreme Court now noted that the other projects were being continued to be run by the IRP, and efforts are also being taken for infusion of funds with active assistance of the ex-management. And so the court observed, and again I quote, in our view, greater inconvenience is likely to be caused by passing any interim order of constitution of COC in relation to the corporate debtor as a whole, and may cause irreparable injury to the home buyers. Now, according to senior advocate Vibhadatta Makhija, just to give you a little more context on the implications of this order, she says that this is a balanced approach. She said that this would ensure that debt owed to a minority financial creditor does not jeopardize the assets of the financial debtor, which is Supertech in this case, because these assets will eventually be the home that will be delivered to the home buyers. I've also written a more detailed article on the Supreme Court order. Feel free to check it out. I'll be including the link to that article in the description of this video. Thank you so much for watching, and do subscribe to our YouTube channel and follow us on Twitter, Instagram, and Facebook.